Okay, so in California, we have something that's called the Homeowner Bill of Rights. The Homeowner Bill of Rights, amongst many other things, says that your lender has to review you for a loan modification. They have to assign a single point of contact. They have to tell you why your loan modification was denied. They have to give you a right to appeal. They can't dual track, which means they can't be reviewing you for a loan modification on one track and foreclosing on you on another track. So the Homeowner Bill of Rights, awesome piece of legislation. It's very old because it was enacted after the 2008-2009 mortgage meltdown to help people stop losing their homes. However, there's big parts of the Homeowner Bill of Rights, or how to use the Homeowner Bill of Rights, that's totally misunderstood. And the best thing I can do is just give you this one example of why I think the Homeowner Bill of Rights is not always the right tool to use if you want to save your home. This is a real life story. I had a gentleman call me who was $200,000 behind in his mortgage. He has a foreclosure sale date that's coming up in less than 30 days. And he said, hey, I think I got them. When he says them, he means the mortgage company. I said, what do you mean? He goes, well, I have them telling me that they refuse to look at another loan modification. Basically, they're sick of my loan modification applications. They've been denied. I haven't performed. They no longer want to look at my loan modifications. So what I want to do is I want to sue them. They did something wrong. I am going to sue them. And I said, sue them under the Homeowner Bill of Rights. Yeah, there's a piece of legislation that says they have to look at my loan modification. They're not doing it. Let's go sue them. And I said, that's great. What do you think that lawsuit's going to accomplish? He's like, well, I can, I'm not going to get foreclosed on. I get to keep my home, et cetera, et cetera. And that's when I come in and say, I don't agree. Now, let me stop here. This is my opinion. This is for informational purposes only. There is no guarantee of what I'm saying is correct. There's tons of different judges throughout the state of California. One judge may say yes, the other judge may say no. That's just how it works. But here is my opinion, not legal advice. SternbergLawGroup.com. You can't sue your lender today under a Homeowner Bill of Rights violation and expect that to go backwards $200,000, which is many months of mortgage payments. Because again, that's what he was trying to do. He's trying to say they made a mistake today, therefore they can't foreclose on me over this $200,000. That's not accurate. That $200,000 that you're behind is not a result of their current Homeowner Bill of Rights violation. So if you go sue them in court under the Homeowner Bill of Rights, the judge is going to look at it and be like, okay, slap on the wrist. You should have reviewed them for a loan modification. I want you to now go ahead and review them for a loan modification. He's thinking that this Homeowner Bill of Rights lawsuit is going to impact his foreclosure today. What I'm telling him is that Homeowner Bill of Rights lawsuit doesn't really have teeth. Like, what are you sinking your teeth into? The fact that they didn't review you for a loan mod? Not reviewing you for a loan mod doesn't make up for $200,000 in missed mortgage payments and the fact that a foreclosure is next month. So just be careful of how you use the Homeowner Bill of Rights, because sometimes it's not the right approach. That's my opinion. That is a summary of how I feel. If you have any questions, feel free to put them in the comments so everybody can see them. Sternberg Law Group, Joshua Sternberg from Sternberg Law Group. Thank you so much.